Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's coverage, we are talking about a whole variety of law stories. We're talking about a whole bunch of things to just catch people up on what is happening in the law. A little legal happy hour, a little, cash hangout session, a little bit of fun with your friend on civil law, a little bit of fun time, fun in the law. Yeah, we're doing all that stuff. All right, so let's go ahead and just start with our fun times. We will start with ex-nurse Radhonda Vaught found guilty on 2 charges in death of a patient. We have been covering this story. We've been covering the trial. We are kind of somewhere in the middle of day 2 right now. And yes, she has been found guilty on 2 charges. So we'll read this a little bit for just a second. A jury has convicted a former Nashville nurse, Radhonda Vaught, of criminally negligent homicide and abuse of an impaired adult after a medication error. The jury deliberated for 4 hours. She is 38. She was charged with reckless homicide, and she was convicted of the lesser included of criminally negligent homicide, so facing only half as much time as she otherwise would have been. Reckless would be 12. Criminally negligent homicide is a maximum of 6. She was supposed to receive a dose of Versad, which is a sedative, but instead injected with versaronium, which is some sort of paralytic. And, that was bad. And that is a thing. Of course, many people are concerned in the medical community about how this might impact them. And just as a way of behind-the-scenes information, I'm currently trying to reach out to some people who might be in a position to talk to us more from the medical side of things in sort of how this might impact their perception of patient care going forward. So, for the legal side of things, I think probably what happens is people will shut the hell up. How that impacts the medical side of things when people are less forthcoming, is also an interesting equation, as always. Yeah. And then, of course, the assistant district attorney said that Radhonda Vaught probably didn't intend to kill her, which if she intended it, that'd be a whole nother thing. We call that murder. But she made a knowing choice. And that's the argument for recklessness, which the jury didn't find. Recklessness has to be knowing. A knowing disregard, knowing and conscious disregard of a risk. So they argued that there was knowing and conscious disregard, but the jury didn't quite find that level of mens rea, so they kicked it down to criminal negligence. This wasn't an accident or mistake. It's been claimed there are multiple chances to just pay attention. Yeah. And then the defense attorney says, I hope it doesn't set any legal precedent. I hope that this district attorney's office or other district attorney's office will not see this as open season on medical errors. So does this set a precedent? Well, it depends what you mean by the question. Does this set a legal precedent? No, it doesn't set any legal precedent. All right. There's first of all, there is no. The answer is just now, no. Right. There's been a trial under a relevant state law. So the only way that this could somehow impact precedent is if the Court of Appeals reverses, and they would have to probably reverse based on some new manifestation of law, because I can't think of any current grounds of appeal. None are apparent. Now, of course, I don't know everything that happened pre-trial. I don't know everything that happened even in trial at this point because we haven't covered everything, but nothing seems apparent. There seems to be enough information for the jury to have reached this conclusion. And it seems like there's enough evidence, and it doesn't seem like you can get to an idea of the overwhelming way of the evidence being against that. I don't think the defense can possibly conjure that no matter what they did or what they did. I just don't see it. So the only way that this could manifest some precedent would be to change the law and change the interpretation of the law in a way that's outside the current law, in a way that would benefit the defendant, which seems unlikely, but you never know. Courts of Appeals can do some weird things sometimes, but that's the only way that sets precedent. Otherwise, it doesn't set any precedent. The statute's been around forever. She's guilty under the statute. It sets no new legal precedent, right? It's not because she was convicted that it's easier in some legal sense to convict people. That's just not how that works. Now, is it a precedent in a more, in a sense of policy? Is it a precedent in sort of perception? It's a precedent in that sense. So again, as nurses and doctors and EMTs and other healthcare workers are looking at their legal exposure, the fact that this prosecution occurred and was successful necessarily increases the perception of their legal exposure rising, which would, if they're rational actors, they would want to do things to decrease that that legal exposure, which may, in some senses, potentially harm people medically. Because if they choose not to talk, that may lead to adverse outcomes where talking could have saved a patient, but maybe it's not in their legal interest to talk anymore. So there's the precedent in that sense. And of course, anytime a prosecutor brings any charge and does so successfully, it also increases perception among other prosecutors that it is more possible than it was. Because these kinds of prosecutions in particular are rare, right? If it's just a murder trial, probably not so much, because murder trials happen all the time. A criminal charge coming out of a doctor or nurse's error, I mean, those are rare. Those are rare. You can count them on one hand kind of a thing. You know, it's just not something that happens. So it could lead to more exposure, and it probably will lead to nurses covering their ass. So it's an exposure in that sense. When asked Friday about the verdict, prosecutors vehemently denied the thing was anything about the actions of one person. This is about what Ravana Vaught did, not the nursing community. Yeah, but the problem from the rest of the nursing community's perspective may be, and obviously I can't get into the cumulative head of everyone in the nursing profession, but it might be the case that the cumulative head of the nursing profession is thinking to themselves, what she did isn't too different from what I do on a routine day-to-day basis. Maybe I should be concerned about my exposure. You know, so it could be a problem. Yeah. So there's all kinds of problems there. Of course, there is no question of malice. No one's claiming that she had any sort of hatred or dislike of the person in the case. So, of course, the Board of Nursing initially chose not to investigate the death. And the American Nurses Association released a statement of concern, saying that it could set a worrying precedent and discourage nurses from reporting errors. Yeah, I mean, it would discourage me as a rational actor. I mean, nurses are not stupid. Nurses are well educated, and they're not stupid, and they're watching this and they're like, geez, you know, if I talk to the medical board, because the medical board people testified, if I talk to the investigators, if I talk to even my own hospital, how will that expose me? So it might be in the nurse's interest, if this were to happen again, to just, and people are saying around, does anyone know what happened to this patient? Maybe the best thing to do legally is keep her damn mouth shut. Perhaps. Maybe. There are countervailing considerations as well, but this is something people have to consider now. You know? This is something people have to consider and weigh as part of the equation. So we'll keep tabs with that. Now, I am interested in the degree to which anyone is interested in me finishing off this case, which seems a bit maybe like there's no point at this point because the thing is over, and I'm not sure anyone will watch it. I don't think there would be enough draw for the channel with the case over for me to continue covering it, but if there's a strong interest, perhaps I will. But let's continue on. All right, so we have another story. A Harris County judge has been grilled following a bid rigging allegations, corruption among the judge. All right. Now, who is this? The leader of Harris County. Okay, so the term judge here is misleading. So we have to start with that right away. Okay, the term judge here is misleading. She's an executive position. She is the county commissioner, right? So she's basically the chief executive of the county, which carries with it in the state of Texas the title of judge. Don't ask questions. Just accept it. Just accept it. Just accept the reality I'm telling you. Okay. So she's not really a judicial judge. She's an executive branch judge. So, yeah. Moving on. Okay. 4 days after search warrants affidavits filed by the Texas Rangers implicated at least 3 senior advisors to, we'll just call her County Commissioner Lynn Hidalgo, in what appears to be $11 million bid rigging scheme. The leader of Harris County did her best to convince reporters it's not what it seems, which makes it seem like what it seems like is corruption. That's not a great place to start. A lot of what was released this past Friday was out of context. Okay. It was private messages, private emails, providing a single side of what took place. Of course, it sounds alarming because it's meant to sound alarming. Not the most encouraging thing you want to ever hear in your life. Hidalgo made a claim of no wrongdoing while not answering key questions as to why little-known one-woman firm with deep Democratic ties was funneled inside information by the judge's key lieutenants prior to the contract going out for bid. Uh-oh. Inside information going out as part of the bidding process? Uh-oh. Or why her current chief of staff ordered the door slammed on the University of Texas Health Center after a well-known institution outscored eventual winner at Elevate Strategies in an initial evaluation. Uh-oh. So when they did the bidding process, first of all, they gave inside information, apparently. And second of all, that inside information apparently didn't work because someone else was able to outbid them using the objective scoring metrics. And then they ordered the door slammed on them in violation of, the law. So, yeah, encouraging. Hidalgo insisted she was following her attorney's advice and not responding. Good for her. Good for her. Judge, by which we mean county commissioner, you say you're a straight shooter, and you said last year from the commissioner's court, which is, again, that you barely know who Felicity was. Now I'll use another term, which is the documents are the documents. The documents from the Texas Rangers show you did know who she was. You're aware of her activities and you're helping her get the contract. Respond to that. Is that not true? Is that misleading? Is that out of context? That is misleading. Unfortunately, I can't explain how, and eventually all the facts will be made public. Good. According to multiple legal experts, the Texas Rangers affidavit offered appears to be what a clear and convincing evidence of misuse of information and tampering with government documents, both of which are serious. Hidalgo was also asked if she planned to fire 3 staffers implicated. From the facts as I know them, what I've seen, there isn't information that warrants that. Hidalgo ultimately canceled the contract back in September. At the urging of County Commissioner Jack Clargy, the Harris County office is seeking to claw back more than $1 million that it was paid to Elevate Strategies before the deal is nixed. So some potential corruption in the heart of Texas. Yeah, so, corruption can happen everywhere, and it looks like it might happen here. It might be for political reasons, which, is not particularly surprising if true. For an $11 million contract that was done with inside information in violation of law, and the people who won were disqualified in violation of law. Kobe asks, is it like an ALJ? It's different than an ALJ. Yeah, it's different than an ALJ. Just think the chair of the county commission, and you're there. It's a weird thing in Texas. It's weird. All right, so let's do another story. Long Island teacher accused of giving a 15-year-old student alcohol and with a little bit of the prurient abuse. Now, I'm sure this is just a tiny little amount of prurient abuse, just a little small amount of prurient abuse. And I've been listening, of course, to the recent testimony of our all but appointed new Supreme Court Justice Brown Jackson. And I have been inspired by her words. So I think that this guy, for just a little tiny bit, the alcohol with just a little tiny bit of prurient abuse, I feel that it doesn't really capture the differentiation between various crimes enough, and I hope he faces no more than 3 months in prison, because that's, that's a good thing. Great. Let's go back. Let's read the story. Just learn a little bit about why this guy might deserve maybe as much as 3 months, but definitely no more than that. Crimes alleged committed 9 years ago are now catching up with the 46-year-old high school teacher who was charged with this week with, the sexual assault by authorities on Long Island. The indictment of Timothy Harrison, 46, on 5 criminal counts, 1 for each of endangering the welfare of a child and 2 for each of third-degree assault and third-degree criminal sexual act, both felonies, was announced Wednesday. Well, it's 5 counts, so maybe 5 months. It was a little bit of misunderstanding, just little tiny misunderstanding. Police allege that he sexually abused a female student inside of his Oak Bench home back in 2013. Harrison alleged the assault of the then 15-year-old student on 2 separate occasions between September and November. He allegedly also provided alcohol to the victim prior to this. Harrison was arrested on March the 3rd after the victim reported the alleged abuse to the Suffolk County Police Special Victims Unit detectives. Harrison was arraigned on Wednesday in a court in Riverhead. He's been released on $25,000 bond. He'll be back in court, and if he could be sentenced to up to 20 years. Yes, I'm sure he could be sentenced to 20 years. But this will be much like the 8.5 to 10 years that Hawkins was facing. Right? It'll be like the 8.5 to 10 years that Hawkins was facing. So since we know, see, we can do some math in our heads, guys. Since we know the proper sentence for the prurient stuff, since we know the proper sentence, if it's 8.5 to 10 years, is 3 months, right? If it's 20, then we'll just multiply by 2, right? So it's 6 months. 6 months in prison would be the answer for this. Well, I'm glad it wasn't anything more serious. I'm glad it was just the two forcible, prurient interactions with the 15-year-old with the alcohol. And I think we can all understand this, and we can just get past this, and we can make this misunderstanding so he won't have to suffer too much, and we can all move on with our lives, because we truly do care about the children in this equation. We want to make sure that they're adequately represented in our sentencing. So we will make sure when we sentence him that we appropriately sit him down and explain to him in really clear terms how much he has hurt this person and how much he has hurt other people, and we will make sure that he understands the harm he's done to the victims. We will give him a chiding of epic proportions, and then we will sentence him to the 6 months, which will show how serious we are. Oh yeah, Kelly, right. Yeah, Kelly, right, exactly. I forgot that part. Thank you, Kelly. I had already forgotten the teachings of Judge Brown Jackson, and I'm so sorry. Right. We also have to apologize to him and his family about how sorry we are that this is happening to him and his family. Absolutely correct. Absolutely correct. Make sure to apologize to him and his family for all this massive inconvenience. 6 months. 6 months is the right answer. Let's move on. Next. Bail has been denied for a driver charged in a DUI crash that killed 2 troopers. Yeah, we also have to talk to him about how hard it is to be a stigmatized member. Yeah, I agree. We have to do that too. See, I'm continuing just the words of Brown Jackson have not truly, I have listened, but I have not yet heard. And I appreciate you renewing my attention to these things. It is also vitally important that we make sure to tell him how we understand how he has been stigmatized. He has been stigmatized, and people might think that, he's a P word. and that's unfair, and how society treats him, totally unfair. And how he's the victim, I agree completely. In fact, now that you make me think about it, I think 6 months is too hard. I'm thinking maybe 5 now, because the stigma is real. The stigma is the thing that really matters, and he'll be on the stigma list, and man, people will just know he's the worst. That's where it's all at. All right, let's talk about the DUI crash, which might result in more than 6 months. A young woman has been arrested and charged with third-degree murder in a crash that killed 2 Pennsylvania state troopers. I wonder how Brown Jackson feels about that. I don't remember anything specifically on point, though. Jana Tani Webb, 21, of Eagleville, is charged with third-degree murder, homicide by vehicle when driving under the influence, homicide by vehicle, second-degree manslaughter of a law enforcement officer, involuntary manslaughter, recklessly endangering, driving under the influence, and traffic violations, including failure to drive at a safe speed, careless driving, and reckless driving. That is a lot of stuff. That is a lot of things. NBC 10 was there as troopers escorted Webb out of state police barracks on Tuesday and transferred her to Philadelphia Police Headquarters. She was wearing the same handcuffs that were carried by the state troopers who had died in the crash. Nice little touch there, I guess, right? Just whatever symbolic value it has. We're leading her out in the handcuffs that were the handcuffs of the troopers she killed. KTB says, I'm not getting the red dot that shows you live on your last few live streams. Not sure if it's a bug, but I see other subs live streaming with the red dots, so I don't know what's up. I don't know what to tell you, man. I don't know anything about how the YouTubes work sometimes. It's a mystery to us all. A judge denied Webb bail at Tuesday night arrangement. Webb will remain jailed ahead of her next court hearing. A little bit unusual. During the hearing, the Philadelphia District Attorney's Office said that Webb gave a post-Miranda rights statement to officers she had been drinking strawberry Henny, referring to Hennessy cognac prior to the crash. Webb's lawyer, Michael Walker, argued the client was very young, a first-time offender, and posed no danger to the public. Number 1, she's not a flight risk. Number 2, she's not a danger to society. And if there's things you can put in place to protect society if you believe she's a danger, like put her on electronic cuff, make her sit in house arrest. And that seems actually pretty reasonable. However, the judge sided with the district attorney's office based on the seriousness of the charges. I do believe there's a public safety issue here. I'm not so sure about that one, to be honest, in this particular hypothetical or real case. Webb sat hunched over the chair in the hearing. She cried quietly when judge denied their bail, but not showing much emotion. Yeah, I don't know. No bail on this hypothetical seems odd. You could just order her not to drive, revoke her license, put her in house arrest, order her not to drink, put up a bond of some amount. I'll order her not to go to bars or restaurants or drink and stuff, all that stuff. So I don't know if I agree with this on this particular case, but that's what's going on. Here are the pictures of the 2 officers that were killed. Martin F. Mank and Brandon D. Siska were both killed. And just incidentally, why do they make them wear these hats with the straps that don't really fit? Who decides that this is a good look for these officers? Who in the uniform department thought to themselves, yes, this is what I want the officers to look like. This is totally the look that I'm going for that will convey the seriousness of their office. Who does this? Startup Lab gives $99.99. That's incredibly generous. Thank you. Great shows recently, Kurt. Keep it up. You found your calling. I think you're happier being a law tuber. You have no fucking idea. From a fellow lawyer, you have my support. Well, thank you, Startup Lab. Awesome. She also violated the Change Lanes Act. I believe that's true. Yeah, I believe that's true. Those hats are a huge meme in law enforcement. Who the fuck picks these hats? Why can't you just pick hats that have chin straps that fit? Why is that so hard? If you want to have hats with chin straps, why can't you make them so that, you know, go under the chin? Who does this? Who decides this is a good look? Can I cut the straps off if I'm an officer? Can I do that? Or can I get a strap that fits? This looks stupid as dumb. This looks stupid as hell. Which I'm now somehow more outraged. I'm not sure what it says about anything about my character or otherwise, but somehow I'm now more outraged about the chin straps than I am about the underlying DUI murders. Because I've been spending a little time on this now. But like, who thought this was a good idea? Because someone made a conscious choice. Maybe that's the difference. Someone made a conscious choice. Someone purposefully and deliberately designed these things and then put them on the people and got photographs like this. And they said to themselves, yes, that was what I was looking for. That was my artistic vision. That was what I wanted. I wanted the chin straps that kind of look stupid as hell. And they continue to do it month after month, year after year, decade after decade. What monster? What monster does this to our officers who are trying to serve the public? Let's put that person in jail without bond. That's what I'm saying. Moving on. Moving on. Maybe we should get some uncivil... Maybe this is the way people like it. Maybe I'm wrong. Maybe it's me. Maybe I'm the wrong one in this equation, and I should be apologizing. So I'd like to announce, right now, I'd like to announce the availability of brand new Uncivil Law merch. Oh yeah, we're making hats with the chin straps. So you can show your support of the uncivil law, because this is definitely what people want, or at least the people in Pennsylvania want, and we want to accommodate them. Uncivil law hats with the chin straps, coming to the interwebs near you. Pre-order today. To non-chin strap related stories. Authorities identify 14-year-old boy who died in an amusement park fall. A terrible tragedy. Yeah, I would think. That's pretty much a bad one. Stephanie says the ocean nightmare. Could be an ocean nightmare. The boy, identified as Ty Sampson, was visiting from home in Missouri with another family. Authorities have identified the 14-year-old boy who died on Thursday night after falling from a ride in Florida. Danger, Will Robinson. The boy, identified as Sampson, was visiting from his home in Missouri with another family. Police previously shared that the boy had died from falling from the Orlando Free fall attraction at Icon Park. And he fell from a ride, which is a free fall ride. So I'm assuming this is one of those rides. That is basically just a straight up column. It's kind of just a straight up column, and you sit in chairs. And sometimes there's like 2 chairs, or sometimes there's 4 chairs that go up and down, or sometimes it's like circular that goes around the thing. And so whatever it is, like they put you in the chair, and then whether it is like 2 or 4 or whatever, 6 or 8 or whatever it is across, right? And they lift you up to the top of the thing, and then it just, free falls. Under control, obviously. And so he was probably up in this ride, and the restraint mechanism failed, which meant that he fell out of the thing and hit the ground. So, now we'll do it. The other horror stories with those ones, The other horror stories that with those ones are the latching mechanisms they use, because every once in a while, someone with long hair, their hair will get caught, and then when they drop, they get scalped. But you didn't know that. Now you're going to really enjoy watching those rides, with long hair. Kobe says, I think you've officially built a brand, because at this point, I'd watch you if you never talked about law again. Excellent. We are happening. It is happening. Yeah. Police previously shared the boy died after falling from the free fry traction. The Orlando County Sheriff's Office role in this incident is to determine whether or not this is an accident. Based on preliminary investigation, it appears to be a terrible tragedy, but our investigation is still open. Well, the thing failed, which shows negligence. So the question might be deliberate or repeated or whatever. So examine those logs and maybe, all that things could be a things. Oh yeah, are we talking about amusement park accidents now? And near accidents? I have stories. But yeah, that's the thing that's happening with this 14-year-old kid. And then finally, to wrap up our show for the evening, it is our friend, Katie Joy Paulson, your friend and mine. Katie Joy Paulson, without the crystal ball herself, it is with sadness and unexpected news that I must inform you that Katie Joy Paulson, and I know you're not going to believe this, looks like she's facing another lawsuit. I know. I was shocked at the news too. I mean, who could have seen that coming? So here's the thing that's happening, okay? Here's the thing that's happening. All right, so this is without a crystal balls. This is from her Twitter. All right, this is from her Twitter. And I'm most decidedly not arguing that any of these things that are represented are true, because I don't know jack shit. But this is what she apparently said. Robert Shin, who's the CEO of 7M, which apparently is some sort of talent management company, we'll come back to that, who she labels as man of God. Hannah Shin, the CFO, manager of the talent, woman of God. Shirley Kim, secretary, 7M Films worship leader. Daniel Joseph, 7M's talent mentor, secretary, and associate pastor. So, okay, that's a lot. The Shenican Church leadership are all controlling the 7M talent management agency. So she thinks there's this church called the Shenican Church. And she thinks this talent management agency is really apparently a religious cult, I guess, is what she's going for. Something? I don't know. Could be. Okay. Carrying on. Miranda and B Dash claim they are not part of a religious group. This is false. They are members of the Shenican Church. Well, that sounds like a damn factual claim, doesn't it now? They are members of the Shenican Church, where Robert Israel Shin declares himself prophet and man of God. That's a factual claim. Hannah Grace Shin is declared woman of God. Factual claim. Shirley Kim is leader of the church worship. Factual claim. And Daniel Joseph is the associate pastor. Factual claims. These are all factual claims. Under 7M's management, Robert Shin is the CEO. Factual claim. His wife Hannah is the CFO, who handles all the finances and micromanages the interactions of talents on sets, along with managing all aspects of their finances. Factual claim. Shirley Kim is frequently on set with the talent and watching everything they do. Factual. Daniel Joseph is the allegedly the designated mentor of the talent, and all dancers must go to him for permission to do anything, including to multiple sources. She claims to have sources. Now, this is a great one, right? Now, we can actually raise a legal point of legal education here that will be worthy of us spending a moment on, okay? Daniel Joseph is allegedly the designated mentor of talent. All right. So maybe you could read this as an opinion. Maybe that's an opinion. But she goes on specifically to say, according to multiple sources. Right. So when an opinion can be understood to convey underlying facts, for the purposes of defamation law, the facts themselves are deemed to be communicated. So if I say, for example, that person X is a racist just generally, right, that's might be an opinion. But if I say person X is a racist according to multiple sources, now I'm claiming to have secret information. And so I'm communicating the facts in the opinion. So you can get to defamation that way. So just the point of education, assuming you could read it as an opinion, it doesn't matter because it's not. Ethical standards for churches will generally state that no pastor should ever serve in a business relationship with their members due to their perceived authority over the members. Now, I don't know where she's coming up with this. How does she know what ethical standards for church generally state? Should she read a lot of ethical guidelines for churches? I don't know that to be true. Okay. Additionally, accepting gifts of members is a conflict of interest. According to whom? You say that's generally true. Is it? Do churches generally believe that? I don't know. Most reputable churches will have guidelines in place to protect pastors and staff from being taken advantage of members. Sharnican Church has no such guidelines, factual claim, and Robert is admitted under oath or in a sworn disposition 2009 lawsuit. He makes all the decisions. Well, he's the CEO of the company. So on some level, of course he does. So, yeah. You know, some level, yeah. Now, of course, 7M themselves have put out a statement, which we, of course, will read. And then, of course, without a crystal ball, of course, manages to make it all about herself, saying that they've named you as public enemy number one. She claims the information she's reported has come from court records, public business records, public nonprofit filings, interviews with the families, friends, and former church members. Well, maybe she has evidence to back everything up. Maybe she's legally protected. Maybe she's got it. Right? Maybe she's got it. I don't know. It sounds like a lot of statements of fact. She claims to have receipts. All right. Individuals that have left the church have spoken out. Choreographers that have worked with him have spoken out. Okay. Maybe she's got it. I've taken statements from public statements, public records, and eyewitness accounts. Their audio of the church shows Robert Shin is described as a prophet and leader of a mighty nation. There are eyewitness accounts, friends, and family who all say the dancers at the Heart Story are members of the church. So she's claiming to have it. She's claiming to have it. She's claiming that she has enough information to believe it to be true without being negligent / without, actual malice. If she has what she says she has, and it says what she says it says, then she's probably in the clear. That, of course, all assumes that she has what she says she has, and, as I was saying, but if she has it, she is probably in the clear. If this was an issue of simply family dispute, there'd be no one else coming forward, yet they have come forward. Rolling Stone conducted their own independent investigation, which came to the same conclusions I've reported. Well, that doesn't really help you that much, to be honest, because maybe the Rolling Stone is full of shit. Allegations I've been sued for defamation are true. Maybe they are. Or maybe if they're not true, because you don't need truth. Truth helps. Truth is, of course, after all, an absolute defense in defamation. If it's true, you can just stop the analysis. So it being true would be nice, but it's not necessary. If she's got enough stuff from enough reliable sources, enough independent people to draw these reasonable conclusions, even if it's false, she's probably in the clear. Oh, yeah. And then another lawsuit is filed by a reality star where I reported on a Dr. Phil episode about dispute between his daughter. The lawsuit is baseless, and we filed a motion to dismiss. Yeah, it is baseless. I don't think I've covered that motion to dismiss. I probably should. Or did I cover that motion to dismiss? I can't remember. But yeah, it's totally baseless. That's that Chrisley guy, right? Chrisley Knows Best, who was suing her. We read that and like, yeah, you got no claim. You got no claims. They're all trash. They're all trash. So yes, that lawsuit was trash. A lawsuit would make public everything from bank statements, contracts with dancers, housing leases, money paid in dancers from churches. Not necessarily. It wouldn't necessarily make it public. It might make it available as evidence in a trial, but that's not necessarily saying it would all necessarily be public. Banks can be subpoenaed, sure. Depositions can be taken, yes. Witnesses can be called, yes. Tax records can be requested, sure. Information about how items were paid and how money is being spent would become public, possibly. I mean, everything would come out, not necessarily. I have nothing to hide, which may be true. And then we'll go ahead and, of course, read 7M's statement here, which I don't think I can actually make any bigger, unfortunately. So I'll just read it to you for anything and see what it says. Yeah, this church is in the United States. You know, so yeah, I mean, but she might have it. She might have it. So we'll see, you know, as it develops, whether she has it. But she says she has it. And so, I mean, so far, she's crushed every lawsuit that's come before her, because all the lawsuits that come before her have been shit. So maybe this is also a shit. I mean, there's a track record of shit being filed against her. So there's that. So this is a statement from 7M Films. 7M Films Incorporated is a talent management company that was born from a series of collaborations between a video director named Isaiah Shin and a group of talented TikTok dancers who felt like they were spending too much of their creative energy focused on business deals that often went unfulfilled and unpaid. Without proper representation, the dancers felt like the industry was taking advantage of their hard work and skills. The dancers knew that Isaiah's father, Dr. Robert Shin, was a respected businessman and asked if he could help with their business affairs so they could focus on the creative side of the work. Since August of 2021, the influencers on 7M's collective roster have grown from 3 million Instagram followers to 7 million followers in 7 short months. That sounds pretty impressive. I mean, whether or not it's all due to the talent management agency is obviously a question, but that's a lot of growth. This is a testament to the hard work and talent of our artists. It might well be. And 7M is proud to be a small part of their success. It is true that the CEO of 7M, Dr. Robert Shin, is also the pastor of Shenican Church. Great. So that solves that problem. It is not true there's any business affiliation between the two entities. I don't know that she said that there was. The Shenican Church and 7M are run and operate separate and apart from each other. It's quite common for a person of faith to own and operate one of many secular for-profit businesses. Sure. Yeah, absolutely. Like, there's nothing inherently wrong with that. People can be pastors and other things at the same time. That's fine. You do not have to be a member of the Shenican Church to be represented by 7M. Excellent. Maybe I'll ask them for representation. Nor do you have to be represented by 7M to be a member of the Shenican Church. Any claims to the contrary are simply wrong. I wonder how many people are in fact disparate, but okay. Shenican Church is a Christian church that was formed in 1994, and contrary to false and inaccurate reporting in the press, has nothing to do with 7M mandate. Well, they are formally independent. That's true. It seems to be, right? But to the degree to which one controls the other, when the CEO of the company is also apparently a pastor of the church, it does raise some questions as to what degree they're in practice independent. But they could be. I mean, it's possible. Contrary to false and inaccurate reporting, has nothing to do with the Seven Mountains mandate, which I don't even know what that is, and I'm not sure I want to know. 7M has no affiliation with Seven Mountains mandate. The M in 7M's films refers to Millennium, a fact which is well documented in his business filings. Okay. Fine. There's a second page. We are extremely proud of the work that 7M has done as a talent management firm, helping so many influencers reach their audiences and find success in the entertainment industry. The style and professionalism of 7M talent set them apart, and that's why so many brands have expressed an interest in and have great experiences working with our talent group. Maybe they have. I don't know. Maybe they have. Maybe they represent a lot of people outside the church. I don't know. Maybe they only represent people in the church, but they either get results. So I don't know. I'm also not necessarily sure if they only represent people within the church that's necessarily bad, because they could be that focused. That would be fine. Like, they're a private company, right? They could do that. It'd be fine. For reasons that are not clear to us or anyone else when it comes to Katie Joy Paulson, an online blogger named Katie, and they use Mansick Paulson here, which whatever, has also been sued by other parties for making false and malicious claims on her site. Yes, but all those other parties have trash so far. So, started a campaign against 7M and the clients we manage, including the despicable act of trying to turn a private family dispute into a tawdry public scandal. Well, to the degree that you have family members who are running the company, which is a public company, even if it's privately owned, right? It's public facing, presumably. I mean, by your own words, incidentally, by your own words, it's public facing, because anyone can be a member of it, regardless of whether they're a member of the church. So that means it's public facing, right? So they're a public company. They might be privately owned, but so if the public company, if the leadership of the company is involved in a family squabble, that has some implications for the company. Now, doesn't it? Now, it's possible to keep those things separated, but it's also possible for them not to. So it might be a reasonable inquiry. She has recklessly defamed many innocent individuals in the process, and she should be held accountable. 7M is exploring and will continue to use every legal means necessary to address these false and unproven claims in court of law instead of the court of public opinion. That's okay. I'll help bring it into the court of public opinion, because that's how I roll. Through my wonderful legal analysis, we're confident the truth will prevail in the end. Well, that is the goal of all trials everywhere. In the meantime, we continue to stand by and support all 7M clients and their friends and families in whatever endeavors they choose to pursue. It saddens us they have to endure this unwarranted campaign of hate. I don't like it when they use that word. That is impacting the lives of so many innocent people. Sincerely, 7M Films Incorporated. And that's all that they have to say about that. So it looks like Katie Joy Paulson might be on the other end of a lawsuit. But given some of the things in the company statement, right, some of the things they're saying raise some questions in my mind as to whether or not they can get to where they want to be. He they can. I don't know. We'll read their complaint, but I'm like, some of these things seem like, maybe she has some good faith basis to think some things, right? He is, in fact, the leader of this thing. Maybe the church and them are more affiliated than you want to let on. Okay, maybe. Oh, it seems like there's a family squabble, but wait a second, the family is like the leadership of the company. Maybe that impacts the company. Could be. So, yeah, it could be, or it could not be. I don't know. And she says she has receipts, so, maybe she's in the clear yet again. Katie Joy Paulson, she can't be sued by anyone ever, because all the lawsuits are always horrible. Yeah. Yeah. So that's all the stories I have for you tonight. That was a lot of stories. I'd like to thank Stephanie publicly, because Stephanie found every one of these stories. She helps me find stuff like this because it just wouldn't cross my radar. Or even if it did, it wouldn't occur to me to pay attention to it, because my mind works differently than hers, which is great, because then she can help me by bringing things to my attention that I wouldn't think of. So all these stories were wonderful. Thank you, Stephanie, as always, for helping me bring these stories to light, and we will continue to follow them and stuff. All that great stuff. Joe Smith said, question, since they used the recording from the civil investigation, if someone waits until they read Miranda, is it already too late? I don't understand the question. When should counsel have been obtained in her case? All right, so let me answer your question this way. It is quite possible that by the time the cops are reading you Miranda, it is too late for you. Right? It is quite possible that by the time the cops are reading you Miranda, it is too late for you. And maybe they have everything that they need. That being said, no prosecutor's ever going to turn down having a confession on tape, because it's like their favorite thing ever. Right? So even though they might have everything, you can definitely make your situation worse. Because maybe the state can prove everything they need to prove. But if it comes from your lips, man, woof, right? So even if they have everything they need, right, you can make it worse. Second, they may not have everything they need. And also, there's a possibility, although it's a bit remote, but it's possible, right, that some of the evidence that they have will not be evidence by trial. It could happen, right? This would be, for example, if a witness dies, if they move, if they can't be located, right? If for some reason the evidence is excluded or whatever, right? So even if they have it now, it's possible, although be it unlikely, but possible, that it may not be evidence by the time the trial comes around. But, none of that really matters if you have the confession on tape. Because who cares, right? So, yeah, I mean, it may be too late. It may not be too late, but it only hurts you to talk, right? It only hurts you to talk. It's only getting worse. Madison says, have I watched the new Legal Eagle video? Yes. It was, again, good. He's right. He's essentially correct. My analysis tracks his analysis. Yeah, so again, Legal Eagle produces a good legal video, and, we're all a little bit confused. Because, yeah, he's essentially correct. Kyle Rittenhouse doesn't seem to have any obvious lawsuits that are available. I've said as much multiple times. Would you support requiring the Fifth Amendment and Miranda v. Arizona applying to civil cases? Well, it kind of does a little bit. You can always take the Fifth in a civil case. The problem is if you do, the judge can order the jury that they're able to take the adverse inference, right? So unlike a criminal trial where your silence can't be used against you, in a civil case it can. It's possible. It's not necessary, but it's possible. So the judge can say that the jury can assume that the answers would be unfavorable to you. And so there's that. But it's not a prejudice in a civil case because the civil and criminal interests are vastly different. And Miranda, of course, itself is a derivative of constitutional guarantees from a criminal trial, which are baked into the Sixth Amendment and Seventh Amendment. So, all that stuff. R. Lou says, would love to see your critique of defense's cross of the hostile witness in the Hussein trial. The woman mouthed off on the stand and supposedly spoke to the jury as she passed them in court. That happens sometimes. It's very, very annoying. Can't have the Fifth when the justice system breaks the Fourth? Of course you can. There are two different constitutional provisions, as you just pointed out. Let's see if there's other questions. Did you see where Donald Trump won his lawsuit against Stormy Daniels? Yeah, you mean recently? Or is this old? With this thing against Stormy Daniels? Because I remember that happening a while ago. Didn't that happen a while ago? Where he won against Stormy Daniels and got attorney's fees and stuff? Didn't that happen quite a few years ago? Unless there's something new you're bringing to my attention. Drama must remain on the stage. But yeah, I remember that happening, unless something like happened today that I'm not aware of. Madison just gives me a little heart. That's very nice. Thank you. That seems to be all the comments for now, although there was some super chats, which we can also take a look at. Make sure to read those off as well. Take a look at Discord, because I think they fixed it. The bot. Did they fix the bot? No. He said he fixed the bot, but he did not fix the bot. So I have to poke into the back end and get it. All right, hold on one second. Because I want to make sure to read all the stuff. see, studio, monetization, super chats. Give me a list, please. There were just the two. Startup Live gave me $99.99, which is incredibly generous. Great shows recently, Kurt. Keep it up. You found your calling. I think you're happier being a law tuber from a fellow lawyer. You have my support. And $5 for Stormcrow 900. You have to keep up the tradition. Look up the Spanish Foreign Legion for classic uniform traditions. Maybe. I don't know. Is there anything more? Because I have energy. We could talk about more things. Stephanie, do you have anything more that you want me to talk about in particular? She appealed it, and the appeal court rules against her. Oh, okay. Fair enough. She just lost her appeal. Oh, okay. Fair enough. Yeah, I wasn't following the appeal, but the trial judge's decision makes sense. It is a case Avenatti botched up, yeah, which makes it hilarious. Kurt, any chance you can explain why other LawTube lawyers grab their chest when you say you're a patent attorney? I can a little bit. Does Stephanie leave? I can a little bit. From my own experience, at least. When I went to law school, there were kind of three major cliques. There were the normal law students, there were the patent law students, and there were the tax law students. And they didn't seem to really... First of all, law school is disturbingly more like high school than you would think. It's more like high school than high school is. It's got cliques, it's got lockers, it's got drama. It's high school. Law school is high school. It's a weird thing, man. Suddenly you got lockers again and periods, and it's just a weird thing. So there's that. But yeah, the patent lawyers and the tax lawyers are kept separated from the rest of the lawyers. Why? I couldn't really say in particular. It's just, well, I guess they're sufficiently different from the rest of the law that the law of the other lawyers are like, no, that's okay. So I think that's a thing. There's definitely some sort of, and I don't think the patent lawyers are necessarily fighting it either. I think they kind of like it. I think they like being in their own little elite world. So yeah. So I think that's, yeah. What did the nurse say to the police that heard her case? So many things. That interview went on for an hour and 50 minutes. We covered it, but among other things she said that hurt her case, no, I didn't feel like we didn't have enough support. I felt sufficiently supported on the floor at all times. Never felt like people weren't listening to me or that I had problems. Felt comfortable on the floor. Felt comfortable in my job. In fact, on that particular day, we had more than enough support. I don't think our unit is big enough that we need a second help all nurse. We're fine with just the one. That med student that I was trained that day, he wasn't a distraction to me in any way. I liked him. In fact, I'd been working with him before, so I was familiar with him, so it was no problem at all for me to do it. Also, by the way, I was totally free to give that trainee to somebody else and get rid of it, but there was no need for me to, because I was just feeling really secure in my job and feeling really good and plenty of support. Didn't feel overworked or overtired, didn't feel stressed. We have plenty of support, plenty of workers that day and every day. And, it's just fantastic. Also, incidentally, I definitely should have checked the vial closer. I definitely should have scanned it in. I definitely should have, double checked. I definitely should have called the pharmacist when it wasn't in the system. I should have done that. Also, I felt bad and felt like, I definitely killed him. So I had to show of remorse. And, I was the one who injected him, so I was the one with the murder weapon in my hand. These were just a few of the several statements she made that were not particularly helpful to her case. You like my lighting? Thank you. Care to shine the light's name? Well, the actual lighting fixture is one of those sort of boxy light fixtures, the Mount Dog. It's one of those sort of tent looking ones, which is not particularly great in terms of that. But it's made by a company called Mount Dog, and lots of companies make light. It's a big sort of tenny thing with a, that the inside of it is reflective and it's got the screen on front. The actual bulb that's in there is where I think the magic happens. It's just a simple LED, but it's at 4,000 Kelvin. And that's the trick, right? Finding the right color temperature. I don't think you want to go too low, and I don't think you want to go high. You don't want to go too high, because if you go too high, you get the blues, and if you go too low, you get yellows and stuff. So you want to look for a nice neutral color. You want that cool white, and I think even even at Home Depot, it's hard to find the right bulbs. Because like they make like cool, I know more about this than I should because I've been looking at lights for a long time. So they make the warm white bulbs that they call 2700. Those are the traditional, it's 2700 Kelvin in color temperature. If you look at bulbs on the packaging, they will tell you the color temperature. It's in Kelvin. So like the cool white bulbs, no, the warm white bulbs are 2700 Kelvin. They're kind of like the sort of amber looking ones. Then they have the ones that are called cool white. Those are 3000 Kelvin. But I don't think there's enough difference between 2,700 and 3,000 Kelvin. And then they have the daylight bulbs. The daylight bulbs are at like 5,000 Kelvin or 5,500 Kelvin. And that produces a really interesting look too. So like you don't want the warm whites because you get that orange and that pollutes the look, and you don't want daylight because that pollutes the look by making it look overly blue. You need something in the middle. And if you go to Home Depot, the ones that they have are 3,000 Kelvin, which isn't that much different than 2,700 Kelvin. So then it becomes an issue of finding bulbs that will do what you want them to do. So Amazon, as always, is your go-to place. So yeah, I just went on Amazon and bought some absolutely cheap-ass bulbs, LED bulbs, but they're 4,000 Kelvin bulbs. And it's the right color temperature. So that makes my skin look great. This is way more information than you ever wanted, but now you know. How goes the gym, buddy? I've been to the gym in a couple days because of this, and I'm way behind, and I'm feeling guilty about it, and I've been tired. I had to take a nap today, so I won't lie. I don't think I've been in the gym in like 5 days, and this is unacceptable for my workout regime. But I will go to tomorrow. I didn't go today because I was exhausted. I had to take a nap, but I will go tomorrow and get back into it. So, yeah. So it's just a like 60 watt or 75 watt equivalent 4,000 Kelvin LED bulb. Do I bench 350? Not now, I don't. My best bench when I was working out for about a year was about maybe 245, 250. When I was working out for a year, I got about that high for a bench, but yeah, I never hit 350. That's a little high for me. Kelvin is a temperature, Shireen. It is a temperature. It's a temperature of like heat. It's also a measurement of color temperature, presumably because something that's that temperature of heat would radiate that color. So yeah, it's also a color temperature thing. Yeah, it refers to the temperature of the star that would emit that color. Yeah, how hot would it have to be to emit that color? So there you go. And finding the right bulb was a challenge. I tried all kinds of things. I tried regular light bulbs. And you go look through my videos as I was searching, man, because I went through all kinds of bulbs. I went through regular bulbs. I had 5,000 Kelvin bulbs for a while. I had floodlight bulbs. I had the stuff from Cree, the really nice bulbs from Cree. They make great bulbs, but not on the right color temperature. I had bulbs from I had a lot of bulbs. I went through a lot of bulbs before I found out cheap ass 4,000 Kelvin bulb was the way to go. Get them in a 12 pack for like $15 or something was the solution to my problems, and it looks great. Why does Streamlabs talk about 7-Eleven? It doesn't. I don't know what you're talking about. Yeah. Progress, not perfection. Thanks. SoCal Chris says, keep it up, man. Yeah, thank you. I appreciate it. $5 from SoCal Chris. Love your show, bud. Thank you. Dark Logic said, what is your opinion, since we don't know what will apply, to the proposition that barring testimony against oneself ought to have been written into the civil context as well? Well, I hadn't really thought about it, to be honest. I haven't really thought about that question about whether or not it would be good to write in the civil context, right? I never really thought through that proposition. So I don't have an opinion because I haven't thought it all the way through. $7-Eleven is a person getting muted by the bot? Probably because they're all caps. Yeah, that would be why. Their messages are all caps. They're triggering the bot for caps. Yeah. Yeah, their messages are all in caps. That's why. It's not that complicated. The bot tells them why. It says why. Please avoid excess caps. It tells them exactly why they're being muted. Excess caps. It's not hard. And it doesn't matter what the message is, because the bot doesn't know what the message is, so it just looks for the capitals. Why would a judge who allowed a witness who planned to plead the fifth to be excused instead of forcing the person to be pled in front of the jury? That's the standard. That's the standard, right? Because it's unduly prejudicial. It's unduly prejudicial. A person has a right to plead the fifth. A person has a right to plead the fifth. So putting them, if you establish that they're going to plead the fifth, calling them to stand just for that purpose is unduly prejudicial, because the jury is going to see them do that, and they're going to draw inferences from that. And so we've just decided it's unduly prejudicial, so we don't allow it. There's nothing to be gained by it, right? It's not evidence. There's nothing for the jury to learn from it. So you're not withholding any knowledge from them that they should know, because the person has an absolute right to claim the fifth. And if they do, then, you know. So by calling them stand, and just for the sake of it, you're giving them information that might prejudice their opinion. So, I mean, that's the law. Super Iron Bob, it says, are there any fundamental law concepts you'd change? Oh, yeah, I got one for you. I got two. And we've discussed this before. Right? We've discussed this before. Constitutional amendments by Kurt, right? Constitutional amendments by Kurt. So what do we want for constitutional amendments? All right, so I got two for you. All right, so they're both very kind of geeky, very technical amendments. $9.99 from Brian says, contributions to the Calvin Club. Thanks. Yeah, I spent quite a bit of money on the bulbs. Anyway, so I have two constitutional amendments for you, both of which are kind of technical. All right, so I want to change the United States from a first past the post system to basically anything else. I will take single transferable vote. I will take approval voting. I will take concordant voting. Basically anything is superior. All right, so I have to explain what the system we have now is, and then I have to explain why the other systems are better. So let me do that. All right, so the United States has first past the post voting, which means the person who gets the most votes wins, which sounds great. But it doesn't require that a person gets the majority. It just requires they get the most votes. So for example, if you have 10 people running in an election, then hypothetically someone can win with 11% of the vote, right? If all the other votes are split evenly, right? So if you split all the votes among all the candidates evenly, every person would get 10% of the vote, right? 10 candidates, each get 10% of the vote. That's 100%, right? Great. So what if you take a little bit from every single candidate and give it to one candidate, right? So you make the one candidate with 11% of the vote. And so now every other candidate has slightly less than 10%, right? So every candidate is pretty close to the winner, and the winner only has 11%. So 89% of people voted for someone else other than the winner. This is non-optimal. This is non-optimal, right? It's like, yeah, it leads to problems. And so it leads to problems for voters because they're pressured from self-interest. They're pressured and from self-interest into voting for one of the two candidates most likely to win. This is one of the things that makes it harder for third parties to win, right? So if you don't really like either of the major two candidates, but you really like a third candidate, then fine, right? If you don't really like either one, and you don't like them either one evenly, then maybe you vote for a third candidate. But if you think one of the two candidates who's more likely to win, if you think one of the two candidates is better, right, then your interest becomes to vote for the candidate who's better, right? It's not your preferred choice. They're garbage compared to your preferred choice, but you want the candidate who's better to win over the candidate who's worse. So you will sacrifice your vote for purely self-interest reasons for the third candidate you really want to one of the two major candidates, because in a first past the post system, any vote that is not for the second place runner is a vote for the first place runner, right? Because any vote that's not a vote for the second place runner is a vote for the first place runner, because the only thing you can do really that makes any practical difference is to vote for the second place winner, which might make them the first place winner, right? But if you're voting for anyone else, it's like it doesn't really matter. So that's what we have. We have a first past the post system, and it kind of sucks. So there are a lot of alternatives to that. Now, there are a couple alternatives, and they all have slightly different drawbacks, but they're all vastly superior. So one thing you could do is what's called approval voting. So in approval voting, you just put all the candidates down who are running for office. Say there's 10 of them running for office. And what you say to the person voting is, instead of saying select your favorite, which is what you normally do, you say select every candidate that is okay with you. Select all the candidates that you approve of. Right? So instead of select one that you approve of, select all the ones you approve of. Right? So as long as you're not voting for none of them or all of them, because if you vote for none of them, then they all get an equal vote. If you vote for all of them, they all get an equal vote. But if you're voting for anything other than all of them or none of them, you're creating a differential vote, right? Some of the candidates will get more votes than others from you, right? So say you vote for 4 of the 10. So those 4 people get one more vote than they did before. Great, right? And so then you just do what you would normally do. You count up all the votes and you see who gets the most votes. It's just now it's an approval system. So you would wind up potentially with something that would look like, so the end result of this might be that the winner of the election got votes from, say, 75% of the population. Second place got 70%. Third place got 63%, and so forth and so on, right? So you might have multiple candidates who get more than 50% of the vote, which is totally possible. But one of them is going to have more than, it's going to be the person who's approved by the most people, right? So the winner is the person who's approved by the most people. So the person who has 80% of the vote beats the person who has 70% of the vote. So that's one way to solve the problem. Another way to solve the problem is what's called a single transferable vote. So basically you do them in a rank order. And then what you do is you put them in a rank order, and you tell the person, okay, instead of voting for everyone you like, vote for as many as you like in order. So put them in order. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You don't have to vote for all 10. Just put as many of them in rank order as you like. Okay? And now what you do at the end of the election is you take all the ballots and you put them in piles that are by the person's first vote. So you take all the ballots and you look at the first person in the first name, right? And you put them in piles by that name, right? So if you have 10 candidates running, presumably you have 10 piles, because probably everyone got at least one vote, right, from themselves. Huh? So, you put them by their first place preference. Okay, so you say, okay, great. Does anyone have 50% of the votes? The answer is probably no. In a 10-person election, right? The answer is probably no. So what do? You take the person who has the least number of votes, you take their pile and you redistribute. How do you redistribute? Well, the voters told you. Remember? Because it's ranked ordered. They told you what to do. They told you their preferences. So you take the person who has the least number of votes, the least total number of votes, you take all their ballots, cross out the first name, on all their ballots, right? Because that person's disqualified now. And now you look at name number 2 and you put them into the appropriate piles, right? Now you have 9 piles. And you do it again. You say, hey, does anyone have 50% of the votes? No? Okay, let's take the person who has the least number and redistribute all their votes. So again, you cross out the top name on the list, which could be 1 or 2 in this hypothetical, because they might have gotten some of the votes from the guy who was disqualified before. But whatever the first name on the list is that hasn't been crossed out. Take the top name, cross it out. They're disqualified, redistribute the ballots, do it again. And you just keep doing that until you get 50%. And that's another way to do it. It's called a single transferable vote. It's also worth mentioning, because people think that this defies the principle of one person, one vote. It doesn't. This is an objection to people who are stupid, because they don't think. So sometimes I've described this to people, and people say, well, that violates one person, one vote, because some people get more votes than others. No, they don't. Everyone has the exact one person, one vote means every single voter has equal voting power. That's what that means. Everyone has an equal vote, and everyone's vote is equal. And some people will say, well, look, in a system like this, where you said, like, some person might get 10 votes, right? Because maybe every single candidate they didn't like got eliminated, so they got to vote 10 times, right? So you take this hypothetical ballot, the ultimate winner is going to be 10th position on their ballot in this hypothetical, right? So you have this person who has 10 votes, the hypothetical winner's 10th, and so you're crossing out 9 names, and so you're like, hey, they got 10 votes. That's not fair. That's 10 times much voting power. And I'm like, you're an idiot. Yes, they got 10 votes, but so did everyone else, right? Because the guy who had the eventual winner in first place, his vote counted every single time. It didn't move, but it counted every single time. It was always in the first person vote pile, because that's what the voter wanted. Every single round, his vote was in the first person pile, because that's what he wanted. Every single round, he got 1 vote, just like the guy whose ballot was crossed out 9 times. Neither of them has more voting power. Every single one of them got an even vote every single round, right? So it doesn't defy one person, one vote. And the same thing with approval voting. Like, oh, like, someone's voting 3 times. Someone's voting 7 times. Someone's voting 6 times. They have unequal voting power. No, they don't, you idiot. Because to vote for 3 is to not vote for 7. To vote for 4 is to not vote for 6. Right? You are giving, every voter has equal voting power. Every voter decides where their votes go to, and every voter counts evenly. So it doesn't defy one person, one vote. Don't be a moron. All right, so there's that. Then there's the best system, which is the most mathematically complicated. So it's the hardest for people to track. Like, first of all, one of the problems is you just have to get people to understand all this shit. And one of the reasons I've explained the order the way I have is because it's from the easiest to explain to the most complicated to explain to the average voter, at least in my view, right? Approval voting, how do you explain it? Just check as many boxes as you want. Whoever has the most check marks wins. It's pretty easy to explain, right? Instant runoff voting, or so instant runoff voting, which is also called single transferable vote, it's the same thing. Instant runoff voting or single transferable vote, same thing. With the whole crossing off the names thing, getting the average voter to understand this, a little bit more complicated. Then we come up with mathematically complicated system called concordant voting, which is fucking nightmare, but it's the best system, objectively, because it satisfies the most criteria. There's something called Arrow's impossibility theorem. And Arrow's impossibility theorem proves it's impossible to design a voting system that will satisfy every criteria you'd want a voting system to have. And it lists what those criteria are, by the way. Like, there's like 3 major criteria. Like, that voting for someone of lower rank doesn't like hurt someone else. There's a whole bunch of criteria that everyone would agree to. Like, these are good criteria for an election to have, for about to have. And Arrow's impossibility theorem says you can't satisfy all of them. So it's impossible to design a system that would meet all the criteria that you'd want an election to have. Can't do it, right? So the best you can do is like satisfy as many of them as possible. And concordant voting does that. It satisfies as many as possible, but it's the most complicated system because you had to design a system complicated to capture as many of these things as possible. So in concordant voting, you do the ranked order thing again, like 1, 2, 3, 4, 5. Except this time, you don't put them into 10 piles. Now it gets really fucking complicated, all right? So now we create a matrix, right? An n by n matrix, like 10 by 10 matrix, right? Every candidate on the horizontal, every candidate on the vertical. And we look at a person's ballot, and we say what the pairwise, we're already using words that confuse people, right? What's the pairwise voting that's implicit in this ballot, right? So if you have 1, 2, 3, 4, 5, what's the pairwise voting that's implicit, right? And the pairwise voting that's implicit is 1 beats 2, 1 beats 3, 1 beats 4, 1 beats 5, 2 beats 3, 2 beats 4, 2 beats 5, 3 beats 4, 3 beats 5, 4 beats 5, right? That's the implicit pairwise voting in that order, right? So then you take all those things and you put a mark in all the respective boxes that I just mentioned for all the pairwise competitions. That's why we did the n by n grid. So you look at where they are vertically, you look at where they are horizontally, and you put a mark in the respective box that reflects that implicit vote. And you do that for all the ballots. And then you see who has the most. And that's the best system, and then you can also wind up in situations so one of the drawbacks of concordant voting is you can also wind up in situations where, because of mathematical reasons, you can wind up in a situation where A beats B, B beats C, C beats A. Right? A beats B, B beats C, C beats A. So you wind up in these circles. And then you have to come up with rules how to break the circles. And there's ways to do that, like you drop the person who has the least total votes. Right? So even though you have this implicit circle that the voters prefer B over A, prefer C over B, prefer A over C. So even though you wind up with circles, you can say, well, strike the one that has the least total votes to break the circle and then see who's on top. So there's solutions to that problem too, but of course it's the most mathematically complex. So this is my proposal for amendment number 1. So probably approval voting or instant runoff voting would be the best, because people can follow it and you don't have to be a fucking mathematician. And could you just imagine with the concordant voting in our system right now, because you'd have to trust the people who are counting them to count them all accurately and create these hypothetical pairwise competitions. Yeah, no problems with that, right? So you might want to create something that's a little bit easier to not fuck up. So there you go. Do that. All right, so that's amendment number 1. And then amendment number 2 is I want to redo districts in the United States so that, because the current law requires that for voting rights districts, the current law requires that every district be contiguous. It requires that it be of equal population. And that's about it. Yeah. So it has to be contiguous, which means that no part of the district can be in another district and no district can be in another district, right? They have to be separate things and unbroken things. So they have to be contiguous and they have to be of even population. And this is like the only requirement to do that. So suppose you want to break up a state into, say, 10 voting districts, right? So all 10 districts have to be of roughly equal population. You're allowed a little bit of latitude. They don't have to be perfect. But so 10 districts, let's say the same-ish, within one voter or something, as close as you can get. So you have to have 10 districts of equal population that are all contiguous. And as you can see from gerrymandered maps, it's really, really easy to do that so many different ways. Like there's almost, you can run a computer algorithm to look at all sorts of different possibilities, because there's, I don't know how many possibilities there are for a given state, but it's a big number, right? How many different theoretical districts can you draw where no district overlaps any other district and all districts have equal population? And the answer is lots. Lots and lots and lots and lots and lots. So that's a problem. So one district cannot be inside of another. No, that they have to be contiguous. They can't be inside of another. No, they have to be contiguous. If it was inside of another, it wouldn't be contiguous. So yeah, you can't do the enclave exclave thing. So Chroma says, how about whoever gets the most votes wins? That's the system we have now. That's the system that I'm trying to replace, Chroma. It doesn't work for reasons I tried to explain. I mean, I'm not sure where we lost you along the way, but whoever gets the most votes wins is the system we have now, and presents all kinds of problems, including strategic voting and people not really getting their preferences. We want a system that allows people to more accurately express their voting preferences than what we have now. So if whoever gets the most votes wins, doesn't work. We need something better. So there's a couple alternatives. Anyways, going back to the districts thing, I would propose that every district has to be maximally compact, which is, and we measure maximum compactness by the ratio of the border to the area, right? So whatever the ratio is smallest is the most compact. So the most compact theoretical shape possible is a circle. A circle has the maximum, it's as good as you can get. It has the best possible ratio of the border, that is the circumference. Well, border, because not all shapes will be circles, so we'll say border, which in this case is circumference. It has the best possible ratio of border to area. So the best possible district would be a circle. Of course, you can't just draw 10 circles in a state, because there's no way that would work, right? Because they're going to overlap and stuff. And that you can't do that because they have to be contiguous. So what you can do is you can compute the ratio for the districts by just computing the border to the area, and you get a number, right? And you do that for every district, and you get 10 numbers, right? And then you can just like average them and say, what is the overall ratio for the state for their districts, right? Just take all 10 and average them together, and you get a number. And then you say, okay, I want that number to be as low as possible. Is this the lowest possible number? And then you can have a computer do that too. And you have them draw a whole bunch of hypothetical districts, and you just look for combinations that have smaller, that are closer to circles. And you can do that too. And there are even maps that will do that for you. I can even show you what that map would look like. Yeah, perimeter if you like, versus border. That will also work. So I can show you what that would look like. If you did that. I just have to find it real fast, but I can show you what it would look like. If you did that. Because people have done the math, obviously. Let's see, come on. That beep is getting really fucking annoying. Hold on, I need to disable that real fast. Drive me crazy. I don't know if you can hear it, but okay. Just go from away from that Bluetooth speaker. God damn it, why can I not find it when you're looking for it? You know, that's always frustrating. This is what I want. No, that's not it. Come on. You hate it when you're looking for something and you can't find it right away. What if I did like a state? Can I do a state? God damn it. I think I got it. Okay, I got it. Great. Thank God. So I can stop faffing around. Okay. So these will not be perfect, obviously, but it'll give you an idea of what we're looking for. Okay. All right. Why is my light out? What do you mean? What are you talking about? All right. So here's a map of the United States as it currently exists. And you can see on the map, and you can see like some districts and how they're drawn. And you can see like some weird shapes in this district, right? And these colors just represent like how Republican or Democrat the various districts are. But you can see like, even in this map, you can see some weird shapes in the borderlines. So this represents House districts, by the way, in case you're wondering what this is. This represents the U.S. House. So these are, every one of these things is a House district. So you can see how like some states have more than others, and you can see some weird lines and some things that don't quite make sense in sort of the order of things, right? So that's what it looks like right now. So if you redrew it along the lines that I was suggesting, because they've already done this for me, I can say, okay, so there's a couple different options, but I want to say make the districts compact using the algorithm. Okay, and so it would change it to this order. And this is what the districts would look like if you did that. And you can see the districts, the lines look a lot different. So this is the district lines if you had maximum compactness. And you can see in this map, you get some circles, because circles are, of course, the best possible result. So you do get some circles, not perfect, all of them, but a lot of them are circles. But you see the district lines are a lot smoother, a lot more even. They're drawn a lot more without so this would be like how you would draw the districts if all the districts were maximally compact. And just to go back to what the districts lines look like now, to show you the difference again, go back to what they are now, and you see those districts. So you can see how big a deal of a difference that makes. And so the nice thing about by the way, and they also have projected what that would mean in terms of just political representation. So this is how it is now in sort of political representation under our current system, at least according to 538, which, they calculate 168 Democrat districts, 72 competitive districts, 195 Republican districts, right? So that's our current split. So we'll say it's 168 to 195 is the current split, 168 to 195, based on current voting patterns, which wouldn't necessarily hold, by the way, if you change this. But if you assumed everyone voted the same way as they do now, which they absolutely would not, by the way. But so it's 168 to 195 now. If you go to the alternate system, it becomes more Republican, 151 to 180. But it's a pure mathematical model, right? So it's not drawn with party representations in mind. It's just, that's just where people happen to live. That's just based on where people live and their current voting patterns based on where they live. So this would, in fact, favor the Republicans for the moment, but I don't think by any means that's any sense long-term. And the nice thing about this model is that it doesn't require a human being, right? It just requires an algorithm. I mean, you could do it by hand, obviously. You don't need a computer. You could do it by hand. It's just that a computer can do it better and more efficiently, right? They can produce more maps and look at more possibilities than human beings can. So, you don't need a computer to do this. You could do it by hand. But the nice thing about it is that there's only one solution. There's only one solution for every state that makes every state maximally compact. There's no other possible solution. And so it takes all the discretion out of the system and makes it just purely mathematical based on where people actually live. It's based on where people actually live, and people are now voting based on where they actually live. So everyone is voting with people that are geographically located to them, which in some sense, one would assume, means that they have somewhat comparable interests versus, you know, someone who lives in a different part of the state. So that's what that would look like. So that is my proposal for 2 amendments. I want to change the voting methodology. Also, by the way, of course, if we change voting methodology, this map would obviously radically change too, right? Because the nature of who people would vote for would radically change. So given my First Amendment proposal, this map, in terms of the representation, is also just out of the water completely, because they vote for completely different candidates. So, but those are my 2 proposals. I want to change the voting methodology. Let's go with single transferable vote, because that'll be easy enough to explain to people-ish. And let's go with this and see what happens. JS, to the extent that you're serious, I'd just like to remind you that you only redraw the lines every 10 years. It's when you do the census. You don't have to redraw them constantly. So to the extent you're serious, Jay, you don't constantly redraw them. You only have to draw them once every 10 years when you do this census. Dazarok says, better yet, just take out the districts entirely and distribute seats according to the state public vote. That would be a different alternative too. I mean, the problem with that proposal would be, like, for example, in California, they've got, I don't even know, 50 people in California, 50, something like that, 50 House representatives. So sure, you could pick the top 50, so you could combine. That'd be a little bit bulky. First of all, you'd have to have a common ballot for everybody, so you'd have to have God knows how many names to elect 50. And then these 50 people, so it'd be get them a ranked order from top 1 to 50 of the statewide popular vote. And the problem with that is that, you know, there's no obviously guarantee that the people represent any sort of geographic interests. So I don't know about that one. Yeah, so 55. I don't know that you want to go to a system where, you have just one big ballot with, you know, 200 names on it, and ask jurists and ask them to pick, you know, as many as you want, 1 through 200. I mean, it seems a little bit unwieldy. You know, districts with 1 person in them is their current system, and yeah. I'm still team make party whips treasonous. The homogeneity of political parties, instead of being local reps, are party members. I think this would change things pretty radically. It would change who becomes representatives pretty radically. I think it would lead to more moderated choices in the whole, and I think it would help a lot on divisions. So that's sort of what I think. There's already a congressional apportionment amendment, maybe, but this is my amendment. What do you want? My amendment's better. Oh, you want to vote for party versus people? Oh, I don't know about that at all. So your proposal is people don't vote for their actual representative; they just vote for parties. So on your hypothetical ballot, it wouldn't present any names. It would just say the parties. So all you would check is Democrat, Republican, Green Party, Libertarian Party, whatever. And the party themselves would choose. So suppose the Republican Party got 10 votes, 10 slots, the Republican Party would be the one who chose those 10 people. So the voters themselves wouldn't be choosing the people. The party would be choosing the people. I don't know about that one, man. I don't know about that one at all. Get rid of the primary? Yeah, I don't know about that either. But those are my proposals. I think it would go a long way to solving our problems in our country. And one of the nice things is that our elections are relatively close in terms of things. So you wouldn't necessarily have to get everyone to understand it right away. I mean, even if 5% of the voters contemplated what you were telling them to do, I think it would make enough difference to actually materialize in the results. And then as more people understood it, it would make more and more difference. So I think you could be satisfied with the fact that, like, even if only 5% of your voters actually took advantage of the ranking system, I think it would make enough difference to actually make a material difference that would start to snowball. I would have people listed by party, and if you want to check the box for party, so you want the ability to just vote for party completely. I don't think I got that. And it was not a parliamentary system. It's not a parliamentary system. His might be. His is a parliamentary system. His is more parliamentary, yeah, where you have party representation. I don't think that's a good idea. Repeal the 17th? No, I don't think so. I wasn't a fan of the 17th, but Kurt wants to make voting harder. I want to make voting to be more accurate, right? So I want the vote to count more information. The problem with our voting methodology we have now is it doesn't convey as much information as some alternative systems do. So it makes it harder, yes, but not for nothing. The alternative systems actually convey more information in the vote. The vote conveys more information. The vote is more expressive of the voter's interests. So the vote is better. It's qualitatively better. So I'm not making it harder for nothing. Have I thought more about Trump wanting to be able to fire more people? Well, non-particular. Proportional list voting is also pretty good as long as the slates are kept short. As long as with, say, 2 to 10 seats to be apportioned. I'm not sure about multiple seat districts. I'm not sure that's a good idea. I think the system we have now with one person per district is fine, and it's just a question of reallocating things. And there's no optimal voting system. This has been proven. You're right, a fuzzy creature. I said this earlier. Yeah, well, there's no system that satisfies every possible criteria you want. It's Arrow's impossibility theorem. Yeah, there's a mathematical theorem that shows it's impossible to design a voting system that would do everything you want to do. So the question is, which one does the most things, and what are you willing to sacrifice of the things for other things? And so it's like, first past the post, though, is just kind of like the worst possible option because it fails so many criteria. Instant runoff voting or single transferable voting is preferable. And we go from there. What are my thoughts on term limits? No particular thoughts. I think this system would sort of obviate that need in some ways, but I'm open to the argument. Do you realize there are a lot of low 90s out there, not age IQ? Not everyone lives in stratosphere with you. You put the people in order. I don't think should be that hard. Like you don't necessarily need to explain to people what. I mean, you can, you can understand it in background if you're willing to think about it, but you don't necessarily need to explain to the voter why they're doing it. It's just like put them in order. Put them in order of preference. So it should be doable, I think. And we other countries do use single transferable voting, so it's not unknown in the world. So I'm going to sign off for now, man. But I appreciate the questions, and I appreciate the super chats, and I appreciate everyone's here. And now you know a little bit more about my hypothetical solutions. If you're enjoying the stream, please remember to give it a like, comment, subscribe. All that YouTube-y stuff, please remember to hit the like button. Remember to you mentioned satisfying criteria. Which criteria is counted as the most important matters then? Could you go into that sometime? Just look up on Wikipedia, look up Arrow's impossibility theorem. It will tell you all about the criteria and what you're sacrificing and not. So, do your own research on this one a little bit rather than having me explain to you. I'm going to sign off for now. I hope all's well. Till later, my friends. Cheers and goodbye.